gets it. We just have to be able to make sure IRS understands that you still have that life, but you do have to file your taxes, pay your taxes, get yourself caught up, and stay current. If you have an IRS issue, you give us a call. You've heard great stories about an offer in compromise from Jim's buddy. And by the way, Jim, thanks for coming on the show today.
Can I say the line?
Absolutely.
Hire a levy, don't get a levy.
He was close. Don't fear a levy, hire a levy.
Okay.
And the other one is you want a levy on your side, not one against you, but it's mighty close. Signing off for now from the Levy Tax Help Show, we have the famous former IRS revenue officer in the house, Greg Mahaffey. Great job, by the way. Thanks for your service to the country. And a nice client, Jim, talking about his buddy from a few years ago for an offer in compromise. Thanks for coming on the show. So, again, it's don't fear a levy, you hire a levy. And you want a levy on your side, not one against you. And signing off for now, we'll sign off from that. Give us a call at 800-TAX-LEVY. If you have a problem, we're here to help you 7 days a week. We're local. We're the best. Come on in. We're right here in Delray Beach to make you sleep better at night. South Florida, you take care. You enjoy the rest of the weekend. We will talk to you next week. Be safe out there.
What's most important? Money? Time? Health? CVS Pharmacy has copays as low as $0 on Medicare Part D prescriptions to save you money. We deliver to save you time. Easier to read prescription labels to help you stay healthy. More money, more time, more health. Switch to CVS Pharmacy. $0 copays for select drugs covered by select plans. CVS Pharmacy does not endorse any particular plan. Not all prescriptions eligible for delivery. See CVS.com or call CVS Pharmacy for details.
When the news breaks, we are the only place in South Florida that always breaks in. News Talk 850 WFTL. Stay connected.
Good Sunday morning to you. I'm CBS 12 meteorologist Kate Wenzel. We'll see a mix of sun and clouds throughout the day. Only a 20% chance of showers, staying breezy at the beaches with our winds out of the south-southeast at 10 to 15, gusting as high as 20. And for this evening, a slight chance of a few showers, partly cloudy skies, with overnight lows dropping down to near 70 degrees.
On the next Markley and Van Camp,
Jussie Smollett, Robert Kraft, the Mueller report. There is a ton of stuff to unpack.
people in Virginia are thankful for the news cycle. Monday afternoon from 1 to 3 on News Talk 850 WFTL.
WRMF HD2.
The following is a paid program. The content has been provided by Vastola Legal. WFTL, its staff, management, and ownership are not responsible for the content. Some of the opinions and endorsements provided herein were in exchange for compensation from Vastola Legal.
Are you ready for some free legal advice? We can hear the roosters, but it's never too early to know your rights. Feel free to call into the show in the next 25 minutes with questions of your own. Just dial 877-850-8585. Without further ado, here's your host of Know Your Rights, Attorney Jeff Vastola.
Good morning. Basically, a natural guardian is someone to whom the law has entrusted custody and control of the child. Basically, that person can do pretty much register the kid to school. Their name will be on the birth certificate, which is the mother, and also they have all the rights to any decision making for that child. So, what are father's rights? Father's rights under this statute. Fathers under that statute apparently does not have any right, because the statute clearly says the mother is the sole natural guardian of the child. So, what rights does the father have? Does the father have visitation right? And the answer is no. The mother can allow the father to see the child if she wants. If she doesn't want the father to see the child, she could simply say no. The father does not have any right to see that child. And what's also important is that, let's say Department of Revenue start a child support proceeding. The father can be paying child support and still does not have any rights to see the child. So now, I know you're probably asking yourself, well, what does the father do? Well, the father has to file what's called a paternity action. And in that paternity action, the father have to establish his right first as the father, and then to request what's called time sharing. And a time sharing is basically a parenting plan where the parenting plan describe what time the minor child will be with the mom and what time the minor child will be with the father. So now, in situation like that, let's say a child is born out of wedlock and the mother and the father gets married. Your next question, does the father have rights? And the answer is yes. If a child that's born out of wedlock and thereafter the mother and the father gets married, there's no need for a paternity action. The father will have all those rights once the parents marry. So it's important for fathers that have children that are born out of wedlock to also understand, what are your rights? What can you do to protect your rights, and understand what steps you need to take to protect to establish those rights. And as I stated before, the main step that you need to take is to file a paternity action. And here at Vastola Legal, we can help you file the paternity action, establish paternity, establish a time-sharing plan, and also establish a child support order. So if you have any issues as far as how to establish paternity, give us a call at Vastola Legal. Our phone number is 561-721-2500. And you can also call me by my cell phone you can call me on my cell phone, which is 561-729-9927. And one thing I want to say is, if you guys have any questions, or if you're listening, you want to call in, feel free to call in, and we'll discuss some of the topics that I just went over. The next topic that I'm going to dive in is immigration law. And the part that I'm going to discuss is removal proceeding. I'm going to go over exactly what is a removal proceedings, what are the stages in a removal proceedings, and what can someone do when they're in a removal proceeding. So let's start off with, what is a removal proceeding? Well, a removal proceeding is basically an administrative proceeding where the government is going to determine whether or not the individual is removable based on violation of immigration laws. So how does a removal proceeding start? Well, the first step to a removal proceeding, for a removal proceeding to initiate, is that the government has to issue what's called an NTA. The NTA is a notice to appear. It's a notice to appear to court. And basically, the NTA, on the NTA, you'll see the allegation that the government is making. For example, let's say you have a non-immigrant that entered the U.S. with a visa, and they overstayed their visa. So in the NTA, the government will say, the NTA will state that you enter the U.S. in such a state, and you fail to leave, and as a result, you're removable. And the government will explain, in these allegations, why they believe that they should remove you from the country. So once the NTA is issued, on the NTA, usually there's a date. Sometimes the government will put a date on there, and sometimes they'll send out another NTA with a court date. That court date is called a master hearing. And at the master hearing, the government will will have the position that this is the claim that they're making. These are the allegations. How do you plead? You could either admit or deny. And you can try to compare it to a criminal case where you can either say you're guilty or you either say you're not guilty. So if you admit, it's similar to saying, yes, I'm guilty. If you deny, it's similar to saying, I'm not guilty. So once you deny the allegations that the government is making, the court will set a court date for the government to make their case. And now the case is up for the government to prove that, one, you're removable, and one, you committed the offense. For example, you came on a non-immigrant visa, a visitor visa, for example. You overstayed it, and as a result, the government wants to remove you out of the country. Now, once that's raised, it's up to you to have a defense. You have to have a defense when you're in a removal proceeding. If you don't, you're removable. You don't have a claim to stay in the country. So once the government is able to prove that, the court will set what's called an individual hearing. An individual hearing is sometimes called a merits hearing. At the merits hearing, let's say the government is able to prove that you were a non-citizen with a visa, you overstayed it, they want to remove you. Now, you may have a relief. You may have an asylum claim. You may have a cancellation of removal claim. Or you may be able to adjust your status, whether while you're in the U.S. And I'm using the example of someone that came in with a visitor visa. So you at the merits hearing, you're able to make that claim, and it's usually the judge will ask each individual's, the amount of times that they need to present their case. It's a merits hearing where you have to, as the and I'm going to say defendant because a lot of people are used to that term, but in immigration law, we don't call them defendants, we call them respondents. You as the respondents you have to be able to present your case. If you don't present your case, you'll be removable, point blank. The judge will issue an order if you don't have any defense. Now, the next question is, what happens after the merits hearing? So after the merits hearing, once the government's proof that you're removable and you raise your defenses such as asylum, cancellation of removal, adjustment of status, and the judge will make a decision. Now, there's two things that can happen. One, on the good side, is the judge can simply grant you your relief. The judge may say, well, you qualify for an asylum claim, or you qualify for a cancellation of removal, and also you're able to adjust your status. If the judge believe that the testimony that you're presenting is true, the judge may grant you the asylum, and that's a done case. The court will be able, the court will grant it, and you'll be able to gain permanent resident status. That's a whole different process. For example, if let's say you apply for an asylum claim, it's granted. There's another step that you need to take in order for you to become a permanent resident, which we will discuss somewhere later, and in the next probably a next series. So what happens when the judge deny your claim? Let's say the judge say, well, your asylum claim is weak. I'm going to order you to be removed from the country. So what do you do now? Well, in every proceedings, you always have a right to appeal. So once the judge issued the order that you're removable, you usually have, well, not usually, you have 30 days to appeal the judge's decision. You have 30 days to appeal the judge's decision. If the judge order you removable, if you do not appeal it within that 30 days, ICE, which is, as I discussed ICE previously, which is the ones that enforces U.S. law, ICE will take you into custody and remove you out of the country. But if you file the appeal within 30 days, ICE cannot execute that order because it's not final. That order is not final, so ICE cannot execute that order. So if the judge deny your asylum claim or whatever claim that you bring, within that 30 days, you have to file the appeal. And with the appeal, you have to file a brief. So what most attorneys will do is we'll quickly file the appeal within that 30 days and start preparing your brief, and then submit the brief, a couple months later, because we're not going to have enough time within that 30 days to write and submit the brief. But what's important is you have to file the appeal within that 30 days, because if you don't file it, and I'm stressing over the 30 days because it's a short amount of time, and a lot of clients doesn't realize that they have to file this appeal, because if they don't file it, the order can be executed and they can be removed out of the country. Now, let's say we filed the appeal, and in the meantime, you qualify for some other relief. Now, a client may come in and say, what are my options? So let's say a client was placed in removal proceedings. He filed for asylum claim. The claim was denied, and we appeal. We filed the appeal within the 30 days. Now, let's say appeals usually take a year or two. Sometimes it may even take more, depending on how backed up the court is. So let's say within a year, my client qualifies for another relief, and they come in, they say, what are my options? Well, the good thing, there is an option. What we can do is, even though the appeal is still going on to what's called the Board of Immigration Appeal, the BIA, what we can do is we can file a motion to reopen your case and tell the judge, hey, my client qualifies for a new relief. Now, when you file that motion, it's going to be up to the government attorney and also the judge to make the decision whether or not they're going to reopen your case. And they make that decision based on whether or not they believe that, you're going to be able to move forward. So let's say somebody gets married and their wife or the husband, the petitioner applies for files a I-130, which is the petition to establish some type of relationship between the wife and the husband. And in that petition, they're able to prove that there is a bona fide relationship that is true. So if the judge believes that, the judge may order the case to be reopened and allow them to adjust their status. So what I'm trying to say is that even though an order is entered, even though the appeal has been filed, there's still ways for you to qualify as a permanent resident in a removal proceedings. And as I said it before, if you have any questions or you need any immigration help, feel free to stop by Vastola Legal. We're located at 240 PGA Boulevard, Suite 192, and that's Palm Beach Gardens, Florida. And also you can contact us via phone. The phone number is 561-721-2500, or you can contact me through my cell phone, which is 561-729-9927. My name is Laitil Ovincy. And to our listeners out there, if you have any question or you want to call in, feel free to call in, and I'll be able to answer some of your questions as far as the removal proceedings and anything else that's related to immigration and also family law. So now, I want to go into what if your claim is denied, and how fast does ICE execute your order? sometimes it's gonna depend on on your on the allegations. Let's say someone was a permanent resident and they committed a serious crime, and they're placed in removal proceeding, and their case is denied. It's possible that ICE may detain you that very moment. Once the judge issued that order saying that you're removable, ICE may take you into custody right that moment. Right that moment, ICE could take you into custody. But if it's, an asylum claim where the individual does not have any criminal records, even though there's an order of removal that's placed, ICE may not, probably won't execute that order that fast. Now, it may come a time where they will, but if you're nonviolent, you don't have a criminal history, the memo is, the government is going to try to detain and deport mostly people with criminal conviction. But over the couple weeks, it has changed where, we're moving swiftly on that. But if you're ordered removable and you don't have any criminal history, it's very likely that you still be able to remain in the country. Now, you're not going to qualify for employment authorization. You're not going to be able to travel out of the country, and there's a lot of benefits that you're not gonna qualify for. For example, a lot of places are not gonna hire you, so it's gonna be to the point where you're either gonna have to leave the country or stay where you're pretty much staying low key. You're scared to go out. You're scared to work because not a lot of places are going to hire you because you don't have authorization to work in the country. Again, if you have any immigration issues, any family law issues such as paternity, child support, divorce, or just you want to establish a time sharing, or you want someone or an attorney to look over your parenting plan if one of the parties are not abiding by the parenting plan, and you want to modify that parenting plan, you definitely should stop by and call Laitil, Ovincy at Vastola Legal, and so that we can discuss your options, your rights, as far as whether you're a father to a child that's born out of wedlock, or you're a mother to a child that's born out of wedlock, and you simply want to know what are your rights. You want to know what can I do if the father comes in and take the child. You want to know your rights, definitely give me a call or stop by, and I'll sit down and I'll explain to you your options, your rights, and what you need to do to protect those rights, or what you need to do to establish those rights if you're a father to a child that's born out of wedlock. And also, if you're going through a divorce and you need an attorney to help you, because divorce can be stressful. Here at Vastola, we make sure that we explain to you your rights and guide you through the process and explain to you the process of a divorce. What you need to do in a divorce, what's going to be established, such as child support, your marital assets, how it's going to be divided, and also if you have a child, establishing a parenting plan that's going to be in the best interest of the child, not necessarily best interest of the father or the mother, but the best interest of the child. So if you fall within those groups or those issues, if you have any of those issues, at Vastola Legal, we'll definitely be able to help you. So give us a call. Again, our phone number is 561-721-2500. And also you can reach me through my cell phone, which is 561-729-9927. And we're shortly coming to an end. And if any callers want to call in and ask any questions and want to discuss either family law or immigration issues such as removal proceedings, or how can I bring in a relative to the U.S., or you simply want to bring your grandparents or your mother or father to the U.S. as a visitor. If you have any of those issues, please give us a call. We'll definitely be able to help you bring your immediate relatives or your father or your grandfather come in either as a non-immigrant, meaning that they'll be here on a visitor visa or a business visa, or if you want, we could bring them in under as an immigrant visa, where they'll come here as a permanent resident status, where they have the opportunity to work and also the opportunity to become a U.S. citizen. So feel free to give us a call. If not, just stop by. We're located at 2401 PGA Boulevard, Suite 192, Palm Beach Gardens, Florida. Again, this is Laitil Ovincy from Vastola Legal. Thank you.
You've been listening to Know Your Rights with attorney Jeff Vastola. Tune in next week for more free legal advice and answers to your specific questions. You can call Jeff on his cell phone after the show by dialing 833-VASTOLA. That's 833-827-8652.